Okay, 9 legalish things. Number 1, you come across questions about confidentiality, NDAs, and non-competes, and the question is, how do I protect what matters most to me? Often what matters most to your company are your clients and your customer base, but there are also going to be secrets, trade secrets, the way you code, the way you research. Or flip the script, you're working for someone else, or you're part of some other organization, and they want to make sure you don't leave with their secrets or with their clients. What are the tools that work for that? What's still there? You hear a lot about non-competes, agreements not to compete. That is, when I leave, I cannot work for your competitor. When you leave, you can't work for my competitor. There's a lot of talk about those in the law. The bottom line is they exist. They're real. They are enforceable. There are limits to how much they can be enforced. You can't do it like 3 years, the entire country. They need to be limited in time and space, and they need to be reasonable. And there's some concern over bargaining power. There was a lot of talk about a year ago about non-competes being completely banned, as they are in California, by the way. That died. It died, frankly, before the administration changed. But once the White House changed, that initiative of the FTC completely died. New Jersey's talked about limiting non-competes, never pulled the trigger on it. They are enforceable. That's the bottom line. And by the way, even people who attack them don't attack non-competes if it's related to the sale of a business. So if you have a startup, you sell it, the person you sell it to says, yeah, now I want a non-compete, man, that is completely enforceable. So read it and pay attention to it. Non-competes have their problems, though. There are other ways you can protect what you're doing. You can do it with things called non-solicitation clauses. That is, you can leave and work for whoever you want to work for, but you can't call on my clients and you can't call on your colleagues who used to work with you. There's no, except for being completely unreasonable, there's no legal limits to that. If you see those, they are enforceable, or if you use them, they're enforceable. And finally, let's talk about non-disclosure agreements. The whole idea of a non-disclosure agreement, I think in a lot of ways, the most powerful form of intellectual property protection is trade secret protection. It's just like we keep it a secret. We don't tell people unless we're in a confidential relationship. It doesn't need to be patentable and meet those requirements. It doesn't need to be copyrightable. It doesn't need to be capable of being a trademark. It's just something I know that I don't want the public to know. That works. It's very powerful protection. But here's the key thing to remember. Every time you share that piece of information, it has to be shared in a confidential relationship. That means with a non-disclosure agreement in place, or to like your lawyer or your accountant, where confidentiality is automatic. If one time you exchange that information without confidentiality in place, it's no longer confidential by definition. Here's why this is key for people like us. There are certainly VCs and private equity people in the world who say, I never sign NDAs. They're not worth anything. And, this is a matter of trust and we don't sign them. Okay. That's nice. That's a nice thing to say. It's bull. Okay. That's not how the law works. The way the law works is if I tell it one time outside of confidentiality, I cannot enforce the confidentiality of that piece of information against anyone. Not just against you, Mr. VC, who you want me to trust, and maybe I trust that you won't use my confidential information. But if that guy uses my confidential information and I didn't have an NDA in place with you, legally, that means it's not confidential anymore to anyone. So NDAs matter. Use them every time.